Oh. Mm. Yes, I'm sorry we are starting a bit late. And the last time we talked about study section 1, and you'll be so surprised this morning that you are seeing me discussing study section 10. The PowerPoint I prepared for study section 2 to 9, I just searched my system now, could not find it, and I'm only seeing the one for 10. But I will also want us to say that we are still going to take this topic, and I don't want to come to the class without taking you with PowerPoint. So we'll take this for now. Then as we continue, I'll go back to study section 2, and we'll move in that order. And we are recording for now. So this study section 10 that we are going to look at this morning is talking about judicial and quasi-judicial power of administration. That is what we are looking at this morning. It is study section 10. It is judicial and quasi-judicial powers of administration. At the end of this study section, we should be able to explain judicial powers of administration. Under the judicial powers of administration, we talk about court and the features of court. We talk about tribunal, the meaning of tribunal, the features of tribunal, and types of tribunal. Then we are now looking at quasi-judicial powers of administration. Then you talk about inquiries and inquiries, the meaning, features, and types. Now, we'll quickly move on to discuss judicial powers. What do we refer to as judicial powers? Judicial powers are powers that is confided in the court to make pronouncement or to give an order that is binding on every citizen that are within the dispute. That is what is called the judicial power. This is confided under Section 6 of the 1999 Constitution of Federal Republic of Nigeria as amended. So the judicial power of the court is actually embedded under Section 6 of the 1999 Constitution of Federal Republic of Nigeria as amended, meaning that when anybody feel aggrieved or his rights has been infringed upon, such a person can approach any competent court to seek redress, and any decision given by that court will be binding on the parties, and this is in conformity with the provision of Section 6 of the 1999 Constitution as amended. We should also take note, by the provision of Section 1, subsection 1 of the Constitution, it said the Constitution shall have a binding force over everybody. That is, all the content of the Constitution is binding on everybody, every citizen, every authority within Nigeria. And Section 1, subsection 3 talks about the supremacy of the Constitution, that this Constitution of Federal Republic of Nigeria is supreme, and any other law enactment in contravention of the Constitution shall be null and void to the extent of its inconsistency with the provision of the Constitution. So it is the Constitution that gives the court the power, the judicial power, to make pronouncements, and the decision of the court in any matter shall be binding, and no party can set aside the decision of the court other than the procedure that is put in place to set aside that particular decision. Then we'll now move on to look at courts. What are courts? These are statutory body. Now, when you say statutory body, in other words, courts are established by laws. Court does not just come into existence. There will be a law that establishes the court. And the law that establishes the court depends on the type of court that we are talking about. So when you talk about court are statutory body established by statutes to adjudicate on matters. In other words, courts are bodies that are established by law to settle disputes between parties. And the law that establishes the court conferred authority on that court. In other words, conferred powers and limitations on that court. And we talk about examples of court. We talk about customary court. The customary court in the southern part of Nigeria, these are courts you find in the local government. They are established by the state government to solve problems that borders on custom. For example, you married your wife or your husband through native law and custom. You marry your wife or your husband through native law and custom. God forbid, two of you are no longer compatible. You do not enjoy the relationship. You do not enjoy the companionship again, and you want to dissolve the marriage. Because to marry under traditional law, under native law and custom, or what you call traditional marriage, the best place you can now go is a customary court in your locality to say, okay, we have been in marriage, we have this, we now want to separate, we want to go our path. The customary court will deliberate and agree and dissolve party and issue a judgment, and the judgment will be a document that says, oh, we are separated. But the question is, can you go to customary court to contract a marriage? The law says, no, you cannot go to customary court to contract a marriage, but you can go to customary court to dissolve a customary marriage. You can go to a customary court to dissolve a customary marriage, but you cannot go to a customary court to contract a marriage. That is what the law provides. It is not my opinion. That is what the law provides. Then we have the magistrate court. The magistrate court is a court that is created in each of the states in the South and called magistrate court, and they deliberate on matters that are within the power of the magistrate. We have the area court. This is peculiar in the North. Then we have the Sharia court. This is also peculiar in the North. We have the state high court. The state high court is also a court that comes into existence by the law that is made by the House of Assembly of the state. They only discuss matters that happen within the state, or which part happen within the state and part happen outside the state. Then we now say, oh, the state high court has jurisdiction to deliberate on that matter. Then we have the federal high court. The federal high court is a court that comes into existence as a result of the law that is made by the National Assembly. Their provisions and what they are meant to discuss is contained under Section 251 of the 1999 Constitution of Federal Republic of Nigeria as amended. Then we have Court of Appeal. The Court of Appeal is the second to the highest court in the land, where a decision is made by the state high court or a decision is made by the federal high court, and you are not satisfied with that decision, you can now go to Court of Appeal to appeal that decision. Then the position of Court of Appeal will stand. Then Supreme Court. We have only one Supreme Court in Nigeria, and it is in Abuja. And the decision of the Supreme Court is supreme. That is, when you are not happy with the decision that is made at the Court of Appeal, you can now approach the Supreme Court. When you approach the Supreme Court, the decision of the Supreme Court is supreme. Now let's look at features or characteristics of courts. Now, when you say a particular thing is a court, what are the features or characteristics? Number one is that a court must be established by statute. In other words, there must be a law that establishes that court. A court must be established by statute. Number two, the court must have its jurisdiction. In other words, a court is not a family meeting that you can say whatever you like. Every court has a matter it can entertain. When a matter is not within the power of a court to entertain, the court will lack that jurisdiction. I've given you, for example, I've seen a situation where the local government officials, they lock up shops. When they lock up shops, they now issue a criminal warrant to prosecute the people at the customary court. The law says no, a customary court has no power to entertain a criminal matter. That is the law that establishes a customary court. So when issues border on criminal matter, a customary court has no power to make pronouncement, because a customary court is not a court that discusses criminal issues. Criminal issues are not custom issues. They are issues that borders on law. So every court, for you to be called a court, it must have its jurisdiction that is provided for by the court. And what is the jurisdiction of a court? The jurisdiction of a court is what the court is meant to entertain. And anything that the court is not allowed to entertain, the court lacks jurisdiction to entertain the matter, and the court should excuse itself from that particular matter. The outcome of a court is a command. That is, when a court makes its pronouncement, it's a command. It's not an appeal. That is, whatever a court says is a command that must be obeyed. So we now say the instruction of a court is a command. If the court say, go and pay, it is not please, you may pay, you may not pay. Pay is pay. So we now say the instruction of a command, it's the instruction and the information that comes out from a court is a command, not an appeal that can be waved aside. No, it's a command that must be obeyed. They are headed by trained judicial officers or legal officers. Courts are headed by trained judicial officers that for you to be a court, for you to head a court, you must have attained some level of legal training, except in the case of a customary court, where they say somebody who has put in level 14, level 15 in the judicial service can be the president or part of a customary court, or somebody who is vast in the custom of the area can be a member of a customary court without necessarily going to training on judicial matter or any other thing, but he has the knowledge of. That is just the exception, that any other person that needs to be part of a court must be a person who has acquired some legal training, maybe studying law, attend law school. But in the case of customary court, a person who has good knowledge of the custom and tradition of that particular area may preside over customary court because of his knowledge in that area. Then also the proceeding in a court is governed by rules. Court is not a market where people behave what they like. The way you have to conduct yourself is also stipulated in a court. So the proceeding of a court is governed by rules. So, and those rules must be followed. And the decision of a court is binding on everybody. The decision of a court is binding on everybody. Nobody has the right to say that it's going to select the content of a court. The decision of the court is binding on everybody. So that is just the principle there. So we must understand those features and characteristics of courts. Then we talk about tribunal. Tribunals are not court per se, but they perform judicial function based on the law that establishes them. Judicial functions are not courts, but they perform judicial functions based on the law that establishes them and gave them the power to entertain specific matters within their jurisdiction. They are not courts, but they are established to entertain some matter within their jurisdiction, and their decision is binding based on the law that establishes them. Because what you need to know here is that you must obey the law. If the law says that the tribunal has a power on this matter, you have no option. You must submit to the jurisdiction of that tribunal. So the tribunal are called quasi-judicial body. They are called quasi-judicial body because they are not really judicial body, but they are established to take judicial matters. So we have examples of some of these tribunals. That is, all matters cannot go to court. Because we don't have enough courts. So they establish the tribunals to entertain some matters. We have the rent tribunal. Now, in Lagos, the rent issue goes to the magistrate court. But in some cases, when there are disputes on rent, it goes to rent tribunal. The rent tribunal adjudicates, try to resolve conflicts between the parties that are involved in that particular matter, and the decision will be binding. Price control board. Today, we don't have price control board. Before now, there was a price control board that when you get to the market, the price to which you want to buy a product is not the price you meet. You can write to the tribunal that, no, the prices are changing unnecessarily. That why are they selling at this price? But that is no longer in existence in Nigeria, but as a price control board tribunal that discuss on the disparity that happen between the prices of products. Industrial Relation Tribunal, when there are conflicts between employers and employees, they can quickly approach the tribunals in order to resolve some of these problems. So that tribunal is also established as a quasi-judicial body that solves problems between the employers and the employee. Domestic Professional Tribunals, that is, when you're a member of a professional body and there are conflicts between the members and the professional body, we have the Domestic Professional Body Tribunal that resolve disputes between the members of that institute and the institute itself. We have land tribunals. Land tribunals is that all land matters are not meant to go to court. That there is a tribunal that can easily be used to solve that particular matter. And that land tribunal tries to solve the problem between conflicts that exist on the boundaries of land, ownership of land, traditional history of land, and other problems associated with land. So there is also a land tribunal before now that solves issues on land matter. We have election petition tribunal. You know, the moment election is completed, and people felt some people will not be happy because of the outcome of the election, the government will establish election petition tribunal that, oh, if you are not happy, write a petition to this particular tribunal, and the tribunal will look at it and decide if your petition is genuine or your petition is not genuine. And they give the tribunal that power, that the decision of the tribunal shall be binding. But when people are not satisfied with the decision of the tribunal, they now go to Court of Appeal and they go to other courts to say they will continue that we are not satisfied with what the tribunal is talking about. The public officers tribunals. That is, we still have a tribunal that if you go to a public place and a public officer is meant to perform a duty and such public officer did not perform the duty, you can write a petition to the public officers tribunal to call that public officers and the institute in order to solve the problem between parties. Departmental tribunal. There could be conflict between one department or the other department within an organization. The departmental tribunal shall be responsible in resolution of this matter. So we now look at these are some of the types of tribunals that we have and the type of functions that they perform. That is, if these tribunals are in existence, you don't need to go to court immediately when there is conflict in this area. You just to write to this tribunal to complain of what has happened, and the other party will be invited, and the tribunal will take a decision on it. And the decision of the tribunal is binding. But where a party is not satisfied with the decision of the tribunal, such a party can approach an higher court that is greater than such tribunal. Then we'll now still move on to types of tribunal that continue. We talk about the social and the economic tribunal, that this tribunal is established as a result of the advancement in the society to solve social problems. We've talked about the rent tribunal, that they solved the rent issue during the oil boom in the 1970s when there is disparity in the price of oil. We talk about the price control tribunal, that is the set price control, that you cannot unnecessarily increase the price of products. Then we talk about industrial relation tribunal. I've told you that this tribunal solve problem between employers and employees of the organization in case there is a dispute. But where people are not satisfied, they can now approach industrial court based on Section 7 of the Industrial Court Act. We have domestic professional tribunal where there are conflicts among the people that are in the same profession and they are not satisfied with what is happening. They can write petition to tribunal. The tribunal can solve their problem. The land tribunal, they solve problem that borders on land disputes between local government, between state, and between communities. We talk about election petition tribunal. These are tribunals that are established where parties that are involved in an election are not satisfied and they are not pleased with the outcome of the election. So they write a petition to the tribunal for the matter to be resolved in the tribunal. We also talk about public officers tribunal. So these are tribunals established purposely to check the rate of corruption among public officers. The Act created the Corrupt Practices Investigation Bureau, while the government was empowered to constitute tribunal to try offenses under this Act. Under the 1999 Constitution, the Code of Conduct Bureau and the Code of Conduct will also be used to check the conduct of the public officers. On that, if you are writing to public officers tribunal, that is when a public officer did what is not meant to do, you are bound to write a letter or a petition to the public officers tribunal, and parties will be invited. And any officer that is indicted can be sacked, can be dismissed, or can be committed to prison. We have departmental tribunal. All of this we have discussed. So we now move on to inquiries. Inquiries, we call them quasi-judicial body. They do not perform tribunal position. They do not perform legal position. But what they do is that they find out facts. They are set up to get facts. And the facts they got cannot be used by the tribunal or the court and can be used to punish whosoever has run foul or caused an infraction to the law. So say inquiries have been defined as a well-published inquisition. Inquisition, that is, you are going to find out, inquire, inquisition on the grand scale, which may not be concerned with the investigation or suspected impropriety or negligence in public life. The aim of setting up inquiry is to satisfy the public that a proper investigation has been made into a particular matter about which there is a great deal of public disquiet. For instance, somebody died in a public school. Maybe they are doing exam in a university and somebody died. Now, there's nobody you will arrest. You won't say somebody killed the person. Maybe there's a stampede during exam and people are pushing themselves. All of a sudden, somebody fell down and died. Who do you want to arrest to charge for murder? You cannot arrest a person to charge for murder. But the family of the people will be shouting, they kill my child in this university. They kill my child in that university. This problem has happened, that problem has happened. Then government can now set up a body of inquiry, a panel of inquiry. What is that body going to do? To investigate what caused the death. Is it they intentionally killed the person? Is it because of the negligence of the authority? What actually caused it? If the inquiry shows that there is a problem, then people can now be prosecuted in court. So, but inquiries mean to investigate into what has actually caused an event. So we are saying that what are the types of inquiry? It could be administrative inquiries. When you talk about administrative inquiry, you want to inquire if the administrative bodies are performing their functions the way they are meant to perform it. Land matters inquiries, if there is a problem on land, you want to know between one committee and the other, you want to find out who is the real owner of that land. Is it this community or that community? Then you go into what? Land matters inquiry. Then chieftaincy inquiry. When you talk about chieftaincy inquiry, this is an investigation into who is entitled to that chieftaincy position. Then you make inquiry, make proper investigation, and make proper recommendation. Disaster and civil disturbance inquiry. If there is disaster, if there's flood, there's problem, you want to know what is actually causing the flood. Does it mean somebody blocked the drainage? Does it mean somebody built house on it? Does it mean government sold the land they are not meant to sell? Or the wet area that they are not meant to build houses? Are people already building on wet area already? Inquiry into disaster and civil disturbance, just like what happened in the toll gate, Lekki toll gate. There was an inquiry that is set up to investigate, headed by a justice, to find out. People were called that, okay, there was civil disturbance, there was quarrel, people were staying in the toll gate. What actually caused it? That is inquiry. That court did not punish anybody. It just find out what caused that particular thing. And we refer to it as a civil disturbance inquiry. Financial impropriety inquiry, where there is money has been stolen, or there is a presumption or allegation that money has been stolen in a public place, and you set up a body to find out what is really happening about the finances of that body, then you are embarking on what is called financial impropriety inquiry. That is, they are not spending money as being required by law. Then, and these types of inquiry is what we have further explained here. We talk about administrative body inquiry, when the government wants to embark on administrative matter or adopt policy on sensitive national topic in order for the decision of the government to be acceptable to the generality of the people. Inquiries are always set up in which members of the public have opportunity to make suggestions to the government. Example, creation of local government, shifting the boundary. Everybody will come and they will make inquiry. Everybody will contribute to it. Land matter inquiry. This is set up in order to maintain peace and settle dispute on land matter. Chieftaincy inquiry. The government set up the body to nip in the bud and the crisis that may arise as a result of chieftaincy matter. Example, the 1968 inquiry into selection of Alaafin of Oyo, the Judicial Commission of Inquiry into Elemuri of Emuri chieftaincy in 1995, the Deji of Akure Commission of 1975. These are bodies that were set up to make inquiry into chieftaincy matters. Then we are still talking about types of inquiry. We talk about disaster and civil disturbance inquiry. This inquiry are set up by the government to investigate the causes of disaster, civil disturbance. Example is Commission of Inquiry into Building Disaster at Oremeji, Ibadan, 1999. A Laganda train accident tribunal inquiry in 1971. Then we also talk about financial impropriety inquiry. This inquiry is set up to investigate allegations of financial mismanagement in government departments, corporation, or government finance projects. E.g., Tribunal of Inquiry into the crude oil sales in 1980. Into the crude oil sales in 1980. The Commission of Inquiry into Africa Continental Bank 1956, Commission of Inquiry into same corporation in 1962, Panel of Inquiry into the sales of land buses in 1978, Tribunal of Inquiry into the finances of Festac in 1976. These are some of the inquiries body that were made. That is the end of the lecture. Thank you very much. Any question?
Good morning, sir.
Yeah, I can hear you. Yeah.
Yeah, this is how doing justice, sir.
Okay, I can hear you.
All right. I just want to ask a question.
Yeah.
Is it ideal to say that tribunals are groups of individuals equipped with delegated powers of the judicial related to the
specific matter?
Yes.
Yes.
Related to the matter brought before them.
Yes. The specific matter they also have authority to sit upon.
Okay. So, sir, what are the criteria in choosing these tribunals?
It is within the power. It's within the power of the people that have authority to choose them. For instance, election petition tribunal, they said the power is confided in the Chief Justice of the Federation or the Chief Judge of the state. So it is that judge that will now look at who is competent and it sets the requirements. But the law specifies who can select such people.
All right, thank you, sir.
Yeah. Then Olowu Yusuf, let me hear you.
Okay, good morning, sir.
Morning.
Yes, sir. Yeah, my question is, sir, in the corporate world and even in the public sector,
yeah,
we do have commissions, statutory commissions.
Yeah.
So some of them have by law, they have the capacity to recruit, promote, and disengage employees.
Very well.
Now, the decision of these commissions is that decision of that does it hold an administrative decision power or a quasi-judicial power?
It holds administrative judicial power and it holds a quasi-judicial power, and it can be contested in the judicial realm. That is, when you are not satisfied, you can take them to court. So they have administrative and quasi-judicial power because they conduct investigation and they pass resolutions.
So it means they hold the two powers together, the quasi-judicial and the administrative.
Yes, yeah. Because they can dismiss. Okay. Once they dismiss, they punish already. Do you understand?
Yes, sir.
They can dismiss. Once they dismiss, they have punished already. So it's like a quasi-judicial. And before they dismiss, they will interview and they will maybe they will they will give query, they will set up panel, they will do a lot of things. In other words, they will now bring parties to explain and they will now come up with a resolution. And those are what is called judicial position. So they have quasi-judicial power and administrative powers. So if you are not satisfied, then you can now go to judicial body to check their powers.
Okay, thank you very much, sir.
Yeah. Any other person?
Yes, sir. Good morning, sir.
Morning.
Yes, sir. Michael.
Yeah.
Michael by name. Sorry, concerning the industrial tribunal.
Yeah.
I want to ask a question. We have an industrial tribunal, and when you are also explaining it, I was meant to understand that we have a body that regulates all form of prices of all the commodity that we are selling.
Yes.
Why is it that now that we are now facing with a lot of things in our own country every day? You go to market today, changes tomorrow, changes today, changes tomorrow. Is it that the body are no more responsible or the body are no more
No,
working?
nobody is writing petition to the body. Nobody is writing petition to the body. It's only when you write petition to the body that the body can now be activated.
Can an ordinary person write a petition to the body?
Yes. Nobody is ordinary. We are all citizens of Nigeria. Anybody can write. Anybody can write.
Can we, sir? I have a question based on what you just said now.
Yes.
Then can we have the address of these tribunals?
They are in Abuja now because they were in Lagos before, but now they are in Abuja. We can Google it and find out, and I will make it available. So that if you are not satisfied with, maybe you go to Toyota, they said the price of vehicle is 80 million, and you know that price should not be more than 50 million. Then you write to the tribunal for them to come and justify why they have to sell that thing for 80 million. And they will call the two of you, and the matter will be tried. And if they now agree to your price, they'll say, no, you can now go with your price. They are in Abuja.
Good morning, sir.
Morning.
Yes, sir. My name is Mrs. Adeyela.
Yes,
while you were taking us, you told us types of tribunals, price control tribunals.
Yeah.
You said they are no longer, excuse me, sir, that they are no longer in use.
Yeah.
So this question that they just brought, I think the answer should be the tribunals are no longer in use.
No, the law establishes them, but people are not writing, so they are just as living dead. Do you understand? Just like you have a car, you just park it and you remove the battery. So, so nobody's writing to it. Nobody's even looking at their side again.
Okay, so we have the board, sir.
Yes,
we have the board.
Yes, they are still there, but nobody's approaching it. Yeah.
Okay, sir.
They are not functioning because we are not writing to them.
Oh, okay, sir. Thank you, sir.
Any other question? Any other question? So in the absence of any question, the video will be made available to you. The PowerPoint will be made available to you. The recorded lecture will be made available to you. Thank you very much.
Thank you, sir.
Thank you, sir.
God bless you.
Have a wonderful weekend, sir.
Have a nice day, sir.